So I think one thing that's clear from all of these discussions is that the theory of holdup is well-founded in economics. I don't think there's much dispute about that. The dispute that I think a lot of people were talking about, at least in the first panel, was whether or not it's happening. And I personally tend to think that that issue is a little bit of a sideshow. I kind of like George's Ebola analogy. It's clear that participants in standard setting organizations, and this happened a long time ago before we all were wandering around the world talking about FRAND commitments and whether or not patent policies needed to be clarified, were concerned about holdup, because that's what the FRAND commitment that many of them incorporated into their policies is designed to deal with. And the FRAND commitment, as I've said a number of times in other places, is really a bridge. It's designed to both ensure that the patent holder gets a reasonable royalty for the use of its technology, and that the implementer is assured that they will not be held up if they implement. Because the fear of holdup, it was feared, would prevent people from, would give people the incentive not to implement, and therefore the standard wouldn't be successful. So no one was really talking about holdout until many of us began to advocate for greater clarity in the meaning of FRAND in order to ensure that royalties being demanded for standard essential patents were based on a valuation of the actual technology that was being contributed, and did not include what many called the hold-up value, or just the value of being standardized. And the courts in the US have been very clear across the board that you don't get to be compensated for the value of standardization. You get to be compensated for the value of the technology that you've contributed, which is a very hard question. I think we're going to reach that at the end of this. But I do continue to find it somewhat remarkable that there are millions and millions of dollars are being expended on lawyers and economists and lobbyists to fight against bringing greater clarity to what FRAND means. I don't really understand that. So holdup is a creature of antitrust, and why is it a creature of antitrust? Because it comes from a process which involves competitors getting together, collaborating, potentially colluding, although I don't think we've seen evidence of straight collusion in anything that we've looked at yet, and potentially conferring market power on one another. Now I say potentially because I don't disagree that not every standard essential patent has market power, and not every time somebody incorporates a technology into a standard, it develops market power. But the reason why we care about it in the context of SEPs in particular is because of this coming together of competitors and the conferring of market power that they do jointly. Holdout, on the other hand, is not a creature of antitrust. There is no market power involved there. Holdout is a creature of the law around property rights, and for more specifically for our purposes, the way that the patent system, at least in the US, works. Validity, infringement, enforceability must be resolved in order for someone to enforce a patent right and collect damages. That's just the way the patent system works, and the patent system does that on a patent by patent basis. I'm not saying that's a good thing, or that it works particularly well, or particularly when you have large patent portfolios, but that is the way it works. And like any other property right, holdout, people can wait to see whether they actually owe you money, to see whether they infringe the patent, to see whether or not the patent's enforceable. Now, I think the reason why we tend to think preserving that right is a good thing is because you want to be able to, the patent system should work in such a way as to kick bad patents, invalid patents, unenforceable patents out of the system. You don't want to leave those in there. And giving people the ability to challenge validity and enforceability is a way to do that. But I really don't think it's any different, holdout is any different than, for example, a squatter. In the US, we have this concept of people who squat on your real property. A squatter is engaged in a form of holdout. It's the same thing. It's not about antitrust. So the last thing I'd say on this is that to the extent that there are those out in the audience and elsewhere in the world who believe that the antitrust enforcers, either here in Europe or in the US, don't consider holdout to be particularly important and don't factor it into our views, it's just not correct. So the whole concept of willingness that you hear people talk about, a willing licensee, in the joint DOJ-PTO statement, it's a person who's engaging in a constructive refusal to negotiate. That's about holdout. So I'm hopeful that we don't have to have a debate anymore about how we unfairly are on the side of hold up and we don't consider holdout anymore. So with those just reactions to what's going on, I'll run quickly through IEEE, which I gather people want to hear about a little bit. So IEEE, obviously they sought a business review letter for us. The business review from us, the business review process is an interesting one in the US. People can come to us with proposed conduct. It has to be proposed. It can't be conduct that they've already engaged in. And give us information about what they are planning on doing and ask for a read from us in terms of our enforcement intentions. So people do this in a variety of different contexts, and it's not unusual for this to come up in the standard setting context. The IEEE business review letter that we issued in 2015 was the third business review letter that we issued relating to patent policies. We did one previous one for IEEE and another one for VITA. So under the process, the department's role is actually quite narrow, and it's to tell IEEE whether the department intended to bring an enforcement action if IEEE decided it was in the best interests of IEEE to implement the updated policy. It was not to determine whether IEEE's policy choices were right for IEEE. Other policies, other standard setting organizations may make policy choices that differ from those of IEEE in order to meet the particular needs of their industry or their members. And as the letter also clearly states, it's permissible for IEEE's policy choices to differ from those that the US government may determine are appropriate in other contexts because the US government does not dictate patent policy choices to private standard setting organizations. So this was really about IEEE's own choice and own decision to implement a policy that they thought was best for IEEE. So we analyzed the competitive effects of the proposed policy under the rule of reason due to the potential pro-competitive efficiencies associated with clarifying the IEEE's patent policy, including facilitating licensing negotiations and improving IEEE's standard setting process. IEEE's request informed us that IEEE proposed to update the policy in 4 ways to clarify the meaning of the R. In the US we say RAND, not FRAND, and the ND in the IEEE RAND commitments. The proposed policy would clarify the scope of the RAND commitment regarding the availability of prohibitive relief or injunctions, the meaning of a reasonable licensing rate, the production levels to which the commitment applies, so who do you have to license to, and permissible demands for reciprocal licensing. After a thorough review, we concluded that anti-competitive effects from the proposed provisions are unlikely to occur and advised IEEE that the division does not intend presently to challenge IEEE's proposal to update its patent policy. We reached this conclusion for 4 main reasons. Licensing rates are ultimately concluded through bilateral negotiations. The specific provisions are not out of step with the direction of current case law in the US. I actually asked someone whether they thought a royalty negotiated under the IEEE policy would be any different than a royalty awarded by a district court in the US applying current patent damages law in the US, and the answer was no. Patent holders can avoid making a licensing commitment under the updated policy and still participate in IEEE standard setting activities, and patent holders can choose to depart to other SSOs. So those are the main reasons. IEEE's, the policy was actually recently had been appealed up to ANSI, and I think on Friday, ANSI just rejected the appeal. So for the moment, the policy at IEEE stands as it was voted out by the IEEE board, and we'll see what happens next on that.